Today is one of the hottest days here in New York. It's over 100 degrees today. And I had a few minutes to share some great information with you. And today's topic is, why is it that when an attorney makes an objection, the jury perceives in their own mind that the attorney is trying to hide something? Why does that actually happen? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, let's say we're at trial. And now, an attorney is asking a question. He's questioning his own witness. And now, guess what? Another attorney, the defense attorney, gets up out of his seat like an ejection button is pressed. "Objection, Judge!" he yells out. "That's hearsay. He can't talk about that." Now, the judge has to make an immediate ruling. The judge makes a decision about whether or not what the attorney has now objected to is correct. If the attorney is correct, then the objection has to be sustained, which means the question is improper and the witness is not to answer that question. So let's say an attorney makes objections over and over again. What is going through the jury's mind about why this attorney is objecting? You know what they're thinking? They're thinking, what's he trying to hide? Why does he keep trying to object? Why does he keep trying to keep this evidence out? Why does he keep saying, "Hey, objection, Judge"? And in the jurors' minds, the only answer, the only logical conclusion they can reach is, he's trying to hide something. What is it that he's trying to hide? What is it that he doesn't want us to hear about? Why doesn't he want this witness to talk about this conversation? What really is he trying to hide? And because of that, you will find that some of the best trial lawyers in New York try not to make too many objections. Because if you make one objection after the next, guess what? The jury gets the perception that you are clearly trying to hide something. And if you're trying to hide something, well, you know what? The jury may ultimately take it out against you and your client. Why? Because they want to know what it is that you're trying to keep out. You know, it's like you put up a wet paint sign on a wall. Everybody wants to touch it to see if it's wet. So if you keep saying objection, objection, and now you raise in the jurors' minds, hey, what's this big issue? What's the problem with this evidence? What's the problem with this question or this topic? Now you've piqued our curiosity. Now you've piqued our interest. We really want to know more. And now that's going to be unanswered throughout the course of the trial, even if the attorney is correct in making these objections. Now, one thing you should know, when an attorney makes an objection, ideally, it's supposed to be done to preserve his client's rights. Now, what do I mean by that? When an attorney makes an objection, what he's doing is he's alerting the judge to a problem. He's saying, hey, Judge, listen, there's a problem here. There's a problem with the way the question is being asked. There's a problem with the evidence that is trying to get in before the jury. There's some type of problem here. I need you to wake up and take notice. And the way to do that is to jump up and say, "Objection, Judge." And now the attorney will tell the judge in a few words what the problem is. Is it hearsay? Is it something that's irrelevant? Now the attorney has to make that legal objection quickly and promptly. The judge will then have to make an immediate ruling on whether or not he agrees or disagrees. But one of the key reasons that the attorney is going to make the objection is maybe the judge has made a ruling before trial and says, listen, nobody is supposed to talk about this topic. And because of that, now this witness is being asked about that exact topic. And he may have an absolute right to do that. And he may be right to do that. The real reason why an attorney makes an objection, not only to keep something out or to make sure the attorney asks a proper question, is for the purposes of appeal, which means that if an attorney loses a case, now he has to appeal it. What is it that he's appealing? He's appealing to a higher court. He's claiming that the judge at the trial level made incorrect rulings of law. If the attorney during trial has failed to make an objection, when it happens, you know what the appeals court says? They say, sorry, attorney, you waived your right to appeal on that issue. Why? Because you were asleep at the wheel. Because you did not make an objection at the time it was happening. And because of that, you no longer have the ability to go ahead and bring this appeal. And because of that, you're out. You have to deal with this loss, and now that's the end of it. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.